Okay, now we're going to talk about impeachment. The rules which underlie impeachment are Rule 613 and to a lesser extent Rule 801A, namely impeachment via a prior inconsistent statement, as the rule is entitled. So I'm just going to go ahead and read it. I'll talk about stuff as we go through and read it. Showing or disclosing the statement during examination. When examining a witness about the witness's prior statement, namely to prove that there is a prior inconsistent statement or that they didn't include something by omission, a party need not show it or disclose its contents to the witness, but the party must, on request, show it or disclose its contents to an adverse party's attorney. What this means is that when you impeach, you do not need to show the witness you're impeaching their statement. You should only show the witness their statement if they say they don't remember their statement and want to have their memory refreshed. If they do, so be it. You show them their statement and you treat it as though it's a refreshing recollection, or as a traditional impeachment where you show them their statement, and it makes them look very bad if they have to ask for their statement. So I would recommend trying to impeach where you do not show the witness their statement. But what you should do, however, is show opposing counsel, because you don't want the opposing counsel mid-impeachment, right when you're at your stride, to say, Your Honor, I need to see what he's reading from, or something like that. Which is really important to know. A lot of people in mock trial don't get this. This is a rule, I imagine, that if you're going to impeach by the quote-unquote proper method of not showing it to the witness, or the most ideal method, you're going to have to explain yourself, and Rule 613A is an opportunity to explain yourself. And then we'll move on to B. Extrinsic evidence of a prior inconsistent statement. Extrinsic evidence, meaning outside factors that make the inconsistency of the statement at hand more or less likely, of a witness's prior inconsistent statement is admissible only if the witness is given an opportunity to explain or deny the statement, and an adverse party is given an opportunity to examine the witness about it, or if justice so requires. Subdivision does not apply to an opposing party's statements under Rule 801D2, namely party opponent statements. So essentially, this is an allowance of rehabilitation. You can't bring in evidence that shows someone's statement is inconsistent unless the other side has, and they usually do in mock trial, an opportunity to rehabilitate their witness. And in the efforts of rehabilitating their witness, you can't then object to the evidence as problematic, because it's all, at the end of the day, going to bias or credibility of the specific witness, which is always at issue. Unless, of course, it applies to party opponent statements, which aren't really hearsay. The piece of extrinsic evidence that is most often used and that they're referring to is an affidavit or a deposition. Remember, those statements aren't part of the record. Those affidavits are depositions, and they technically count as extrinsic evidence of a prior inconsistent statement. So, like, the evidence that, like, Dr. Couples lied in his statements on the stand is that he wrote this report and it didn't include what he said on the stand, or it just explicitly contradicted what he said on the stand. But that report isn't an evidence, so it's extrinsic evidence in the most legal of the terms. So you can't use the affidavit to impeach unless they have an opportunity to use the affidavit as well. So, like, you can't use the affidavit to impeach them, and then if the opposing counsel either references or just gives the witness back the affidavit and gives them an opportunity to explain, you can't then object to hearsay or something, because that document isn't an evidence. That's not how it works. If you've essentially opened the door, and rehabilitation is an acceptable purpose for using that document. That's Rule 613. When it comes to impeachment, for those of you who don't know, the process is going to go something like this, especially if you're trying to do it without showing the witness the statement. Now, Dr. Couples, you wrote a report for today's case, right? I did. And in doing so, you included all relevant examples for your findings. Yes, I did. And everything you included in that report was truthful. It was. And then you take it over to opposing counsel. Your Honor, I'm approaching opposing counsel. I'll be referring to Dr. Couples' report in its entirety, or if you have a specific line number, I'll be referring to paragraph 16 of Dr. Couples' report. And then show the opposing counsel, come back to your location. Nowhere in this document do you say X, Dr. Couples, right? Or in paragraph 16, Dr. Couples, you say blah, 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 blah. Am I right about that? If they say I don't remember, you show it to them and go through it that way. But otherwise, you've said the statement. Hopefully, the statement contradicts what they just testified to on the stand. You look great. They look like a liar. Bingo, bango, bongo. You're done. That's impeachment. And so now, for real, we'll be moving on into the expert stuff next video. Thanks.